Well, before we begin, we should confess that we're so interested in this case that a certain amount of thought and research has been going on. So we've got things that we ought to mention to you. They may or may not make any difference to anything, but Lord Briggs would like to draw your attention, if you're not already aware of it, of the situation in the Rolls building.
I'm sure you know that e-filing is now routine in the Rolls building, and they maintain in the foyer, or the atrium of the Rolls building, a row of computer terminals upon which members of the public can search and look at documents, and then ask for copies to be made of those documents which they wish to take away. The terminals don't have any copying facility built into them, and quite deliberately. That's a system which has just been announced is being rolled out around the country to all the business and property centres. I think it's about 5 or 7 cities around the country. What I don't know, and haven't had time to research, is just what is included within what is filed electronically as available for public search on those terminals. But it might have some bearing on the issue about what the records of the court are or may be in an e-context, an electronic context.
Well, it may be some indication of what the people who are
Think,
responsible
yes.
for providing that access
Correct.
think.
Yes, correct.
But so that's one thing.
I'm very grateful.
The other thing, well, Lady Arden has been looking at the Public Records Act.
Shall I just briefly explain that I wanted to find the statutory authority for maintenance of court records. There is a provision in the County Courts Act 1984, which I did not copy, but looking more generally, the Public Records Act 1958, Section 8, imposes the responsibility for court records for every court of record or the magistrates' courts which are not in the Public Record Office or a place of deposit appointed by the Secretary of State, and then gives him power to determine, in the case of any such records, the officer in whose custody they should be. And it contains a reference then to Schedule 1, which sets out the records of courts and tribunals, and it then contains it in paragraph 3 of Schedule 1, paragraph 1, subparagraph 3, therefore. In this paragraph, records includes records of any proceedings in the court or tribunal in question, and includes rolls, writs, books, decrees, bills, warrants, and accounts of, or in the custody of, the court or tribunal in question. So that, I think, it's subject to correction, is where the statutory responsibility for maintenance of records now is.
Lady, yes. We addressed that, I'm very grateful, paragraph 39 of our case, and I will take you to the Public Records Act 1958. We say it's neutral in relation to the determination of this issue before the court, but I will come back to that if I may. So far as concerns the position in the Rolls buildings, may I gratefully adopt the observation of my Lady Hale. It's rather like the position of what happens to be on the court file in the underlying litigation. Well, what happens to be on the court file in the underlying litigation in this case is an administrative decision which happened to also include a case of Deanne. But it cannot be a case of the tail wagging the dog. It is for this court to determine, obviously, the proper meaning to be accorded to CPR 5.4C2 and no other. And by parity of reasoning with the CPRC, of course, it's relevant and interesting to see what the Rolls building is doing or has done or is about to do, but it does not determine the issues before the court. If the approach in the Rolls building is one of transparency, plainly it supports our case that transparency has been recognised already. The other relevance to e-filing, which we made short reference to in our written case, is of course that practical difficulties concerning the storage of documentation will inevitably reduce with the passage of time as the reforms are being rolled out.
The absence of an inclusive definition, a fully comprehensive definition, is an indication that Parliament did not intend to prescribe for the court what the records were, but to allow the courts to determine that for themselves
Exactly.
by their practices.
Well, that's the point you make in your case.
That we would say is exactly the position. It's an inclusive, not exhaustive definition, which itself is by reference to the language which would have been the appropriate language in 1958 and which has not been updated. For instance, expressly to cover those documents which we know to be court records as set out in paragraph 4.2 of Practice Direction 5A. And that's why I say it's neutral in relation to the issue. And for the record, my lady, that Public Records Act is at 3320, that's section 8, and the paragraph 4.1 that my Lady Arden drew our attention to is at 3337.
Thank you.
Lady, we moved on from 1372 now to 1965. And can I invite the court to turn to page 3510, which is the annual practice of 1965. There you'll see it, but then to 3519. Which contains Order 61, Rule 17. That's 3519 in the middle, under the heading Indexes to Files to be Kept. And it's short, it reads, proper indexes or calendars to the files or bundles of all documents filed at the central office shall be kept, so that the same may be conveniently referred to when required, and such indexes or calendars and documents shall at all times during office hours be accessible to the public on payment of the usual fee. It says this is taken from C Order 1, Rule 46. Well, that was the earlier order that I took the court to yesterday. That provision was described at page 2019 in a case called Cadham and Beaverbrook Newspapers Limited by Gerald Gardner QC, as he then was, see page 2016, but at 2019, as part of his submissions, in the middle, he says the Detroit rule as to pleadings being private documents is different from the English rule, for under Rules of Supreme Court Order 61, Rule 17, it's open to members of the public on payment of the appropriate fee to read all the documents in a case. See also Order 61, Rule 24. Many people do not know of those rules, for they do not read so far in the annual practice, and therefore they are seldom used. But they are there and show by their terms that in relation to civil suits, it is considered to be in the public interest that these matters in pending proceedings should be available to the public. That was picked up in a case called Ex Parte Associated Newspapers Limited, which the court will find at page 2027. These references are in our case, but I'll give them to the court now and just show the court if I may. Which you can see near the top. The counsel indicated the matters of great public interest. The history is that on the 29th of January 1959 in Cadham and Beaverbrook, counsel for the newspaper, Gerald Gardner, called attention to the existence of Order 61, Rule 17, a rule which had been somewhat overlooked. And that's where you get the reference to you can get a mandamus. Now, that's not a mandamus against a underlying litigant. That's a mandamus against a court officer who doesn't give you the documents that you're entitled to under Order 61, Rule 17. And that's the case, Ex Parte Associated Newspapers, that you see referenced in the commentary to that version and later version of the Whitebook. Can I then turn to Order 63, Rule 4, and that's at page 3529. This is in a 1967 Supreme Court practice C3526. 3529, down towards the bottom, the court will see Order 63, Rule 4, right to inspect, etc., certain documents filed in central office. And 4.1 says, any person shall on payment of the prescribed fee be entitled during office hours to search for, inspect and take a copy of any of the following documents filed in the central office, namely A, B, and then C, with the leave of the court, which may be granted on an application made ex parte, any other document. And we say the insertion of the words court records into the civil procedure rules do not change fundamental positions so far as concerns filed documents. And that is any document, so long as it is filed in the central office. And over the page at 3530, you were taken to part but not all of the commentary. First part, under the heading Scope of Rule, says this rule replaces the former Order 61, Rules 17 and 18, which are derived from C Order 1, Rules 46 and 47, and those are the rules that I've taken the court to. And underneath that, you were taken to a passage describing the restriction, and then it continued, so I'm now 3/4 of the way through the second paragraph of the commentary. Nevertheless, even in respect of such documents, leave of the court may be obtained for search and inspection by a person not a party on an application made ex parte to the practice master in the QBD, etc. I said I would go back to the Regulation Act 3 and 4, which was referenced in one of the early Chancery rules. And this is just to give the historical perspective to the Public Records Act 1958 that Lady Ivans drew our attention to. And can I, for these purposes, go to page 3244? There the court will see Public Record Office Act 1838. And Section 9, Master of the Rolls to make rules for the management of the office and the admission of persons using the records. And first of all, it says that the Master of Rolls has the power to make rules, etc. And in the middle, you'll see for making copies of records, it's about 8 or 9 lines down. The other part I wish to draw the court's attention to is at the bottom. As the court see, it says nothing herein to affect 3 and 4 W4C.94. So the Public Records Office Act didn't affect what we see at page 3235. Which is the act referred to, and that's, as you see it near the top, it says an act for the regulation of the proceedings and practices of certain offices of the High Court of Chancery in England. And if the court will go over the page to page 3236 to section 10, which is at the bottom, the court will see, and it be further enacted that any person should be at liberty to take an office copy of so much only of any decree, order, report, or exceptions as he may require, and that unless the court shall otherwise specially direct, no recitals should be introduced in any decree or order of the said court, but the pleadings, petition, notice, report, evidence, affidavits, exhibits, or other matters or documents on which such decrees or orders shall be founded shall merely be referred to, and it should be lawful for the Lord Chancellor, if he shall think fit, together with the Master Rolls and Vice-Chancellor, or one of them, to make and issue such rules and regulations, etc. And that rule and regulation was the first one that I took the court to, that C.0 Order 1.4, because that we saw was a provision amended, or I think uses language altered, by this Act. So historically, the Public Records Act, which we think is the first one, 1838, did not address the Chancery Master's reports, including documents, affidavits, exhibits, etc. They were dealt with under the 3 and 4 Act and the rules that I've taken the court to. All of which, in our respectful submission, rather undermines the observations of Lord Justice Potter in Geo to the effect that there has historically been no right which enables a member of the public to see court documents. I'll just give you the reference. That's 1161 F to G. Don't ask the court to turn up now.
Sorry, can you give me that page number again?
Yes, my lord, it's 1161
Thanks.
F to G. My lady, I believe that was my 5th point in support of the submission, that the key is filing.
Yes, I stopped you going on with it, didn't I? I'm
Well,
afraid.
you
Yes.
didn't, my lady, and we're now at the last one, which is, the 6th point is that the approach which we invite the court to adopt accords with a range of domestic cases considering the civil procedure rules. What I'm going to do only is make reference to the paragraph in our case. It's paragraph 41 at pages 175 to 176. And there are a number of their first instance decisions. I'm not going to use time to go through them in turn, but they all support the approach which we propose to the court, leaving only Geo, which we address in our case at paragraphs 47 to 50, that's 177 to 178. In short order, Geo was decided under the rules of Supreme Court, not the civil procedure rules. Appears to have treated lodging of the trial bundle as not being equivalent to filing, when we would submit it was. And for those purposes, see Order 63, Rule 5, which is at page 3714. 3714. So I'm in the 99 version of the White Book. You'll see at the previous page, 3713, we've got Order 63, Rule 4, which was in force at the time of Geo, which provides that documents filed in the central office are accessible. And over the page at 63.5, 3714, where the court orders any documents to be lodged in court, they must, unless otherwise directed, be deposited in the central office. And you'll see under the heading History of Rule and Practice that the proper place for the deposit of deeds and documents under this rule is the Filing and Record Department. Which makes sense because that process of lodging is exactly equivalent to the process of filing.
But the bundle, the trial bundle, is only a convenient collection of the documentary evidence which the parties propose to adduce. It's not actually in evidence, is it, until it's actually produced at the trial starts and the trial bundle is produced. And it may be that only specific documents are produced. So it's of a completely different quality from the affidavits and so on that we've seen referred to, because the affidavits are required to be filed by the rules with the application or in response within a given timetable. It's not so with the trial bundle.
Lady, under the rules of the Supreme Court, the trial bundle was to be lodged. Under the civil procedure rules, the trial bundle is to be filed. That's order CPR 39.4.5. So, first of all, I'm here simply trying to deal with Geo But under the civil procedure rules, the trial bundle absolutely has to be filed. Secondly,
Just on that.
Yes,
I mean,
ma'am.
these rules, just looking at them quickly here, seem
Yes.
to use a concept of filing, which seems to be different from lodging. Can you help us with that?
not only in the way I'm seeking to do, they have used two words in the same way that when you go to the guidance for the Queen's Bench Division and Chancery Court and Commercial Court, sometimes the word lodging has been used, sometimes the word filing has been used. And that must be for historical reasons. What I've sought to do is to show you how they effectively define lodging in Order 63 Rule 5. And that is absolutely the equivalent to filing. That's the submission I'm making, my Lord. In any event, under the civil procedure rules, the trial bundle has to be filed. And in response to the observation of Lady Arden, our case is that on filing, that document is put before the court. The trial bundle is before the court. We then move into the arena which I've already made submissions on, namely that whether or not a judge pays heed to a document in the filed trial bundle matters not. You put in a trial bundle documents which you rely on or refer to. That's what you are achieving by creating a trial bundle. And further, on the facts of this case, for the avoidance of doubt, all of the documents, I've made a submission already, all of the documents in Bundle C, it is common ground, are documents which were referred to and relied upon. Geo did not consider the case of In re Hinchcliffe, which is the case that says if an affidavit has been filed, a non-party can see the exhibits, even if the exhibits haven't, as a matter of convenience, also been filed. And for that, see bearings at paragraph 47, which is page 2418. I'm not proposing to go to it. Let's give you the reference, if I may. Geo misconstrued the approach historically to access to documents. I've made that submission just earlier. Geo anticipated the need for change. See at page 1163C. And it may be convenient for the court to just go to that page, please. So this was Lord Justice Potter recognising that it's of great importance that the beneficial saving in time and money, which it is hoped to bring about by such new procedures, should not erode the principle of open justice. And change there has been, culminating in what Lord Justice Toulson recognised was, in his words, breaking new ground, decision of Guardian News. Accordingly, Geo was, not that we have to show this, but was wrongly decided. Anyway, is not binding on this court, and was not even binding on a court at first instance. See the careful judgment of Mr. Justice Bean in 2014 in the case of NAB and Serco, paragraph 29, which is at page 1486. It is a judgment at first instance, but it's a judgment which, if the court has the time and inclination, we would invite in its own time to go through that and the Blue and Ashley judgment of Mr. Justice Leggett.
Sorry, when you say GIO was wrongly decided, in what respect?
Aspects that I've sought to just to cover, but
Which is what? Sorry, just to summarise for my note.
my Lord, yes. Geo held that lodging is, in effect, lodging is different from filing, and I've made that submission that it isn't materially different at all.
Is that the bit that you're saying it was wrong about?
There's a part about what I'm saying it was wrong about. Right. I'm also saying that it didn't take into account In re Hinchcliffe, which it should have done, it wasn't drawn to its attention, that it didn't take into account a historical perspective. And that is why, if you go to page 1486, Mr. Justice Bean would not rush to say a Court of Appeal case did not bind him, nevertheless set out and gave his reasons along the lines I hope to have enlarged upon. I do not consider these observations remain good law.
Yeah, that's not to say it was wrongly decided.
Forgive me if I've used language inappropriate to, then I'll withdraw it and convert it into observations to not remain good law.
Well, his reasoning in two respects relies on subsequent developments.
Lord, yes, and my lady, apologies.
So-
Yes,
so-
and it doesn't actually matter. We don't have to undermine GEO, because GEO is a decision in relation to rules of the Supreme Court when the language of lodging is used. And yes, part of my case relates to the development after the rules of the Supreme Court civil procedure rules.
Well, he gives three reasons, one of which is germane to the actual decision in GEO, and the other two are reasons why it shouldn't be followed.
My lady, yes. Lady, can I move now to the fourth topic, which is the scope of the inherent jurisdiction of the court. That's Appeal Ground 1, so Cape's Appeal Ground 1. Cape's case in their grounds, which are at page 20 and following, reduced to two submissions. First, the open justice principle is already given effect to by various provisions of the CPR. And the Court of Appeal's approach cuts across the balances struck in the CPR. Secondly, the scope for the inherent jurisdiction of the court is limited to that set out in GEO, namely skeleton arguments. Our response in writing is paragraph 66 to 76, which is 182 to 185. And all these submissions, my lady, proceed on the footing that the court has found that the jurisdictional reach of CPR 5.4c2 does not cover trial documents. Now, on the first issue, for the reasons that I've already made submissions in relation to, the question reduces to whether the exercise of the inherent jurisdiction contravenes the civil procedure rules. The forum's essential submission is that it cannot sensibly be contended that the exercise of the inherent jurisdiction to further the open justice principle, itself an aspect of the rule of law, contravenes the civil procedure rules. CPR practice directions are now made pursuant to the Constitutional Reform Act 2005, see section 6, which is, I'll give you the page number, it's 3445 to 3446. Section 1 of the Constitutional Reform Act, which is at page 3428, provides that the Act does not adversely affect the existing constitutional principle of the rule of law. Whilst there is no express equivalent provision in the Civil Procedure Act, which starts at page 1578, there is absolutely nothing to suggest that the 1997 Act had the effect of cutting down the court's inherent jurisdiction, let alone to further the open justice principle. Likewise, there is nothing in the rules themselves which could be interpreted as having this limiting effect. And see here the judgment of Mr. Justice Leggett in the Blue and Ashley case, at paragraph 11, and I'd ask the court please to turn this up. It's at page 1541. This is a case in which a non-party sought access to witness statements before the trial. Paragraph 10 addresses submissions I've already made, and simply note it up and ask the court in its own time, please, to read paragraph 10. But for these purposes, I move on to paragraph 11. I also reject an argument made by counsel for Mr. Ashley that it's implicit in Rule 32.13, that's the cite of witness statements during the course of the trial, that a non-party cannot be allowed to inspect a witness statement until the statement stands as evidence in chief. CPR 32.13 gives a non-party, unless the court otherwise directs, an automatic right to inspect a witness statement which stands as evidence in chief during the course of trial, without the need to obtain the court's permission to do so. But there is nothing in CPR 32.13 which prevents a non-party from applying for permission, or which prevents the court from granting permission to inspect a witness statement before the automatic right conferred by 32.13 has arisen, even if it could be read as having that implication, which to my mind it cannot. The rules of court which are contained in the statutory instrument are not to be interpreted in the absence of language which makes such an intention plain beyond possible doubt as limiting or controlling the powers of the court in this context. It's all there in paragraph 11. It's absolutely right in our respectful submission, and it applies equally to an application made after the trial as it does to before, which point itself addresses in part the observation of my Lady Arden in relation to the significance of the trial bundle documents once they've been filed. And of course he continues, Lord Legate continues, Mr. Justice Legate continues at paragraph 12 to say it's one thing to conclude, as I do, the court has power to direct a non-party should be given access, and another to decide the power ought to be exercised. And this appeal is only a jurisdictional appeal, dealing with the court's jurisdiction, not the issue of the exercise of a discretion. Lady, on the second issue, the scope of the inherent jurisdiction is anyway limited to that set out in Geo. The forum's case is that the court should exercise its inherent jurisdiction by setting a default test in favour of disclosure of documents referred to in open court. That's copy of paragraph 85 in Guardian News, as in so doing it would be furthering the open justice principle, which it is in the interests of justice so to do. I make three submissions in support of that proposition. First is that the court has an inherent power to control its procedure, which it should do to enable it to carry out its functions properly. See two cases. First, Al-Rari, paragraph 18 per Lord Dyson, that's page 1275. May I ask the court please to go to that? 1275. You'll see at the bottom at H, under a heading, the inherent power of the court to regulate its own procedure, that Lord Dyson makes a distinction, and this is in partial answer to the observation of my Lord Sales, viz. What's procedure and what's substantive. And here Lord Dyson was seeking to distinguish between the paradigm developing the duty of care, common law, substantive, and what he describes as exercising your inherent power to control your own procedure, which he then considers in further detail in paragraphs I'm going to go to. And see also the case of Nye Credit in the House of Lords, at page 2297, C to D. This is the case that addressed not just the issue of when does a cause of action materialise, but also then the power of the court to award interest. See at page 2297b to C. It also requires, in suitable cases, the House should have power to award interest on amounts ordered to be repaid. Otherwise, the unravelling would be partial only. This power seems to me to fall squarely within that range of powers which are necessarily implicit if a court of law, possessed of, in that case, appellate functions, is to carry out its prescribed functions properly. The second submission I have to make is that in this context, the court has a constitutional duty to secure open justice. Quoting there from Sir Ernest Ryder at paragraph 12, I'll just give you the reference in his lecture at page 5188, in which he says the judiciary, but that's indeed the court. 5188. And it would be furthering the principle of open justice by applying its inherent jurisdiction in the way that Lord Justice Toulson set out at paragraph 85 in Guardian News. That's at page 1355.
Do we have an explanation why the forum didn't apply for access to documents during the course of the trial?
My Lord, it may be a case of me giving evidence, but the position is entirely straightforward. The forum is an unincorporated association with very limited funds which it seeks to use for the benefit of asbestos victims. No member of the forum knew of the existence of this litigation at the time. I think myself, for instance, I'd been notified by counsel about a year before that there was some litigation proceeding against Cape. My instructing solicitor then attended a lecture given by counsel for the underlying claimant in the PL action, which put her on immediate notice because counsel in the lecture they were giving were indicating that the documents in the case which had just settled were extremely important, having then written asking for the parties to keep hold of the documents, the parties saying they wouldn't do. That's when, at very short notice, I was instructed and went off to Master MacLeod to obtain the orders that I did back in March or April 2017.
Yes, thank you.
My Lord, we're dealing here with, and I'll make more submissions on this later, we're dealing here with what we might call practical realities. There is a quote, I think Mr. Bunting has set it out in his written case from one of the higher courts, I forget which case, indicating that even the media can't be expected to attend every case, let alone an unincorporated association doing its part as a pressure group come support group for victims of asbestos exposure.
One can expect them to inspect court records, the court files.
Yes. And just to finish that off, one can't then expect them to obtain the transcripts. That would have cost tens of thousands of pounds that they do not have. The transcripts were obtained by live note, by the parties, put up with the judge, and never given to us. The position has been absolute from the underlying litigants throughout. Absolute position, no. We will not help you with anything.
In Guardian, the journalist wanted the information in order to write an article about the proceedings.
Yes.
Is it any different if there's any other purpose in the person, the third party, seeking disclosure? Does the purpose make any difference?
My lady, no, but may I please ask to come to that, because it's one of the, it's I think, second ground of appeal. If that's all right, my lady, may I
Yes,
come back to it?
Well, it could be relevant to the exercise of the court's discretion,
Very, very much so, my lady.
but not to the existence or non-existence of the discretion, the power.
My lady, as is the position in the Supreme Court, under Rule 39.
Yes. But we've got a very clear rule.
You have a very clear rule, which entitles all members of the public, I think you say, and media, for the avoidance of doubt, they are members of the public, entitles all members of the public to apply to the registrar for inspection of all of the documents that have been filed, which will of course include the appendices and the underlying documentation. Be it a contract of insurance, a contract of employment, or whatever other document has been filed. Can I now seek to address, at least in part, I say in part for a reason, the observations of my Lord Sales concerning the threshold tests, in which I say in part because the way we would put this is query whether the court has to be satisfied that it is necessary to apply the inherent jurisdiction. And I say query because the approach of the courts we can see has used or employed different language. If we go back to, if we may, our Rari and the judgment of Lord Dyson at page 1276.
Are we still part of your second point?
My lady, we are. Why is the scope of inherent jurisdiction not limited to that set out in Geo? May I invite the court back to page 1276? The court will see at paragraph 18, there's reference to the article by Sir Jack Jacob, quoted, the court may exercise its inherent jurisdiction even in respect of matters which are regulated by statute or by rules of court, so long as it can do so without contravening any statutory provisions. And Lord Dyson continues, in such a case its power has been removed by statute and cannot be exercised. And he continues, in proceedings which are not regulated by statute or statutory rules, it might be thought that there are no limits to the inherent power of the court to regulate its own procedure, and that it has an untrammeled power to manage litigation in whatever way it considers. And then he says, necessary or expedient in the interests of justice. Of course, expediency is convenience, not the same test as necessary. But what he focuses on, we see this in the next sentence of paragraph 20, is there are many examples of the court in the exercise of its inherent power introducing procedural innovations in the interests of justice. And then he references Moreva injunctions and Anton Pillar orders, and also indicates that discovery emanated from the inherent jurisdiction of the court. See the remainder of paragraph 20. Language used, I've taken you to this quote, so I'll just give you the reference. It was a Kennedy per Lord Toulson at paragraph 118, and the page number was 1442. The language that Lord Toulson used was that it was being proper under the open justice principle. And I also took you to the language that Lord Mance used in Kennedy at paragraph 47, which is at page 1420, which was as being required, which sounds like necessary. So I don't shy in any way from meeting a threshold of necessity. It's simply not absolutely clear to the forum that the test extends that far for the reasons that I've just given. And the essence of the test is it in the interests of justice? And that would fit with the approach of Lord Toulson. Is it proper? Should we do this? Not is it necessary, should we do this in the interests of justice? But we don't shy from it, because the position we're addressing here is one of asking the court to apply its inherent jurisdiction in circumstances where, under the civil procedure rules, per the Court of Appeal and per Cape, which is how we're taking it at the moment, there is no power vested in the court at all to provide a non-party with a single disclosure document, however much that may be key to providing the public with knowledge of what is going on. That's language borrowed from a Lady Hale in the C case at 1523. So yes, in these circumstances, we do submit that it's necessary for the court to draw on its inherent jurisdiction in the interests of justice. How else would the courts be able to avoid too wide a gap between what has in theory and what has in practice passed into the public domain? That is, again, to borrow from Lord Bingham in SmithKline Beecham 1179E. Lady, the third submission I make is that there is a boundary to the invocation of the court's inherent jurisdiction. That is, that it should not be applied in a way which denies parties their fundamental rights. This was clearly articulated by Lord Dyson in the Al-Rari case. Can I ask the court to go back to paragraphs 21 and 22, 1276 to 1277. Paragraph 21 you were taken to, and that is the paragraph in which Lord Dyson says, in my view, so I'm picking it up between G and H, there is considerable force in what Professor Dockeray says in his article, and for these purposes I'll just pick up the end of the article, which is over the page, at B, which is major innovations in procedural law should therefore be recognised as an institutional responsibility, etc. You were taken to that. And then he continues at paragraph 22. For example, it's surely not in doubt that the court cannot conduct a trial inquisitorially rather than by means of an adversarial process, at any rate not without the consent of the parties, or hold a hearing from which one of the parties is excluded. These admittedly extreme examples show that the court's power to regulate its own procedure is subject to certain limitations. The basic rule is that subject to certain established and limited exceptions, the court cannot exercise its power to regulate its own procedures in such a way as will deny parties their fundamental common law rights to participate in the proceedings in accordance with the common law principle of natural justice and open justice. But at the same point, in a different way, the court must exercise the power to regulate its procedure in a way which respects these two important principles which are integral to the common law right to a fair trial. Sorry, about to.
Well, I did want to ask, Mr. Fordham makes the submission that the court ought not to order a party, once, say, the files have been returned to it, to reconstitute the files that were before the court. I mean, we're dealing with an unusual situation because the master had the judge's trial bundle. But are you saying that the court has jurisdiction to order a party, after everything's been returned, to reconstitute the trial bundle?
My Lord, may I address that first by emphasising what your Lordship's already indicated, namely that is not critical to this appeal for this case.
Well, just on that,
No. Yes,
I was a little bit unclear reading the master's order,
yes, my Lord.
whether she was saying that access should be given to the trial bundle which the judge had, which seems strange because the judge will have marked that up, or whether in fact the effect of her order was that CAPE would have to reconstitute the trial bundle and that would be provided.
Lord, she was giving access to the trial bundle that the judge had, or as we believe in fact had not really marked up, because it was those bundles of papers which for regrettable reasons, we don't want to get bogged down in that part, but see the judgment of the Court of Appeal, were actually removed from the court and taken to lead offices and then returned to the court.
So was the order that she made directed to the judge's trial bundle?
Yes, it was.
Right.
We know that to be the case because those very papers were the papers which were taken.
Yes, thank you. But going back to the earlier...
Going back to the earlier, as a sort of matter of principle, but not directly affecting this case, my Lord, yes, the court can see the judgment of Mr. Justice Leggett. I think it was the paragraph 11, paragraph 10 sorry, I'm grateful, paragraph 10 in Blue and Ashley. Can I invite the court back to that? I was going to develop something on this point later, but page 1541. And this is always subject to the court's discretion. This isn't some determination that the court simply will absolutely require of parties after the event return of documents. This is a discretion This is the application of inherent jurisdiction in which a party would be entitled to attend and say, please don't exercise it in this way. I see the approach of Mr. Justice Leggett. If we pick it up at about D, the statements were filed for the purposes of 5.4c2. That's because C earlier, we would say, appreciates that all that's key is filing. And he says the fact that the court may no longer have a copy of a document on its file, for example, because the document was filed only in hard copy and was returned after the hearing, will not prevent the court from ensuring a non-party can obtain a copy if the open justice principle requires this. The court could, for example, order one of the parties to file the document again, or to provide a copy directly to a non-party. Moreover, there's nothing in the CPR which precludes the court from making an order under its common law powers to enable a non-party to obtain a copy of a document which has been served in litigation, even if the document hasn't been filed by a party. We don't need to go that far. That's how Mr. Justice Leggett sees it. But I'm going to give a more specific response, my Lord. That's a very general proposition to this case, if the court was minded to order that the non-party provide a clean copy, which it can comfortably do in the facts of this case. But I'll come to that later on. Lady Cape is not contending for a countervailing common law right in this case. The court's invocation of the inherent jurisdiction in this context cannot, therefore, be criticised on the basis of the court stepping in and legislating where it should not. We're wholly removed from a case that was referred to in writing but not orally by Cape, called the Siskina, which starts at 2080. I'll just deal with this shortly. This was a case in which Lord Denning in the Court of Appeal was seeking to extend the jurisdictional reach of the English courts to cover any foreign case at all, simply on the footing that the defendant had assets in this country. See the summary of the position by Lord Diplock at 2128 F to G. Denning was not seeking to further any common law constitutional principle. He was simply seeking to provide what he considered to be a just result. See what he says at 2106 in effervescent language. We are far removed from that scenario. I propose to move on rather than giving the court time to read it, just if I may, to keep the show on the road.
Instead of saints, read judges.
My lady, having made those submissions on inherent jurisdiction, can I now turn to, and then I hope to enlarge upon some of the issues which have been raised.
Just before you do,
Yes,
can I just ask you this? I can get my head around the concept that while a case is proceeding towards trial, and the parties have, for that purpose, submitted to the jurisdiction of the court, and the court is vested with its usual case management powers, I can quite understand, I think, as a matter of concept, whether it's right or not, the court making orders directly against those parties, for example, to reconstitute some bit of the court's records that's been lost by being handed back to them. I have a little more difficulty in seeing how that works once the judgment has been given and the case is effectively, at any rate at first instance, there may or may not be an appeal, over. For how long do you say the court retains that jurisdiction in relation to those who were parties to that litigation?
My Lord, Lord Nyson referred to procedural innovations in our realm. The court has to understand that once the source is the need and interest of justice to further the open justice principle, the court can take these steps. One, it is no part of this appeal for this court to determine the period of time that documents should be retained by the court, or B, the period of time over which the court retains an inherent jurisdiction to obtain documents from an underlying litigant. That is not before this court. Those are precisely the sort of concerns that this court may choose to give guidance on, or may choose to ask the CPRC or any other body to consider, investigate and legislate on. It's not, my Lord, seeking to duck the issue. We're dealing here with a jurisdictional issue. Is there in principle jurisdiction vested in the court after the resolution of a underlying piece of litigation? I don't seek to belittle practical issues by palming them off, but I do seek to palm them off because we are concerned with the jurisdictional reach of the court, not the exercise of its discretion and the full extent. Is there a jurisdictional reach?
But I think I understand you to be saying, albeit cautiously and politely, as a matter of jurisdiction, that time is unlimited. Although it may become increasingly remotely unlikely that it would be exercised.
My Lord, that would be a matter for a court. It may be that on a given application, to exaggerate to make the point, for a case that settled 45 years ago, a given judge would say, I do not consider I have an inherent jurisdiction. It may be a judge would say, I consider I have it and I'm not going to exercise it. And that may itself then be appealed and may come up to this court, and the court will then address that sort of an issue. But we are off-piste so far as concerns the essential issues before the court, in our respectful submission. My lords, my lady, so far as concerns the issue of mandatory orders, the forum makes two submissions on this issue. The first is that the Court of Appeal should not have made the order it did, and it should simply be set aside by the Supreme Court, which is invited by the forum to restore the order of Master MacLeod. Secondly, in any event, the Court of Appeal did have the power to make such an order, not least on the facts of this case. In relation to the first submission, the forum's application was at all times for copies of documents held by the court. (5.4c2) involves an application to the court, and the inherent jurisdiction of the court involves an application to the court. See here, Guardian News, paragraphs, I think it's 10 or 11, and I'll just give you the page number. Page 1336, paragraph 10. Prior to delivery of it's page 1336. Prior to delivery of the district judge's judgments, the Guardian wrote to the court asking to be provided with copies of various documents which had been referred to in the course of the extradition proceedings. That was an application to the court for the court to provide those documents, which Lord Justice Dawson held the non-party was entitled to. The Court of Appeal had held that the forum was entitled under inherent jurisdiction to access to a range of documents, subject only to determination by Mr. Justice Picken of whether some of the documents didn't fall within the scope of the court's jurisdiction. Further, the court knew that an appeal was afoot. In those circumstances, in our respectful submission, it should have heeded the submissions made by the forum, which are at I've got the reference, but not the reference with it's pages 965 to 966, paragraphs 13 to 16. We made in writing that the right order was that the court hold the documents and produce the documents. On that basis, whatever has happened in this case, the court need not be concerned that mandatory orders will be made as a matter of routine in the future, because the application is an application to the court. The second submission is that the court anyway had the power to make the order it did. And for these purposes, can I start by going to the terms of the order? It's page 225. Page 225, paragraph 3 at the top. Not so much a mandatory order as a permissive order. The appellant is permitted to retrieve from the court office of the Queen's Bench Division all documents and bundles currently located there, save those on the court file. And it was making a permissive order, framing in that way, because it was the appellant, Cape, which had sought custody of the documents. And that's set out in their skeleton argument in support of that, pages 943 to 946, in support of which it gave 4 reasons, including practical ones. At this stage, we have appellate litigation. And it is a moot point whether Cape, as the appellant, is an interested party or a party to litigation. If it's a party to litigation, then the court can rely on CPR 1.3 and the requirement on the parties to help the court to further the overriding objective. And Cape was saying, we'll help you. We'll manage out the business of providing the forum with an appropriate copy. And that's my completion of the response and the observation of my Lord Sales. Because Cape wants to do this. And Cape has, as we know, a full electronic version of the bundle. So there is no problem in practice in relation to this case.
So when you say the bundle, do you mean bundle C?
Everything.
Right, but we're talking about bundle C.
Absolutely, my lord. Bundle C, but Bundle C is actually the disclosure documents. They also have electronic copies of the witness statements and the expert reports and of the transcripts. So it's not just Bundle C, it's that compendious description I've given, trial documents. All of that is available to Cape electronically, and Cape asked for and obtained permission to provide delivery of the relevant documents. See their skeleton argument. At page 944, paragraph 6, and then over the page. So they say, the effect of para 3 to 7 of the order is the judge's own copy of the trial documents either be seized and retained by the court or provided by CIH to the court should be returned to CIH. That's Cape. Cape will then be required to provide to Mr. Dring copies of such documents as he may properly obtain in accordance with the terms of the court's judgment or the inherent jurisdiction. So they've asked for and been given permission to be responsible for producing such copies of such documents as this court determines the forum should be entitled to. And that can be achieved without any regard to the issues relating to marking up of bundles by trial judges.
You say they've asked for it. They seem to be asserting that that is the effect of the order.
My Lord, I've sought to say they had 4 reasons. One is they say that's the position. I've sought to explain why the Court of Appeal was wrong in relation to that, because this was always an application to the court. And then they give practical reasons, as you'll see, when you go down from 945 to 946. So third, the approach cannot conceivably prejudice Mr. Dring. Fourth, such an approach will reduce the burden on the administrative resources of the court. That's a practical reason. Second, the approach means documents provided to Mr. Dring will not include documents drawn from the trial bundle provided to Mr. Justice Picken, which may have been annotated by him. So there is an open invitation to the court, which the court accepted, that they will provide clean copies of such documents as this court determines.
Yes, they're describing their draft order in response to the Court of Appeal's judgment. Is that right?
Yes, they are. They're
Yes.
describable. I think
Where do we find their draft order?
It's all very close by.
I'm sure it is.
Well, I'm sorry, I will seek to find it. It's 953, lady. That's Cape's draft, and you'll see at 954, paragraph 3, that became the court order.
Yep.
So that's why I say, in this case, the practical issue relating to marking up of bundles by trial judges simply does not arise. For the future, it may be that this court gives guidance that a witness bundle be maintained by the court, which won't be marked up. And of course, once we have electronic bundles, none of these difficulties arise. Those are matters for this court either to express its view in relation to, or to delegate back to whichever power-making body it considers, such as, for instance, the CPRC. And further in relation to this issue, the court, if Cape is a non-party, has the power under the CPR to make orders for disclosure against non-parties. That's 3117. Let's give you the reference, 1739. And 3118 at 1740 provides that the rule in 3117 does not limit any other power which the court may have to order disclosure against a non-party, which we would submit includes under the inherent jurisdiction of the court.
Sorry, what was that latter reference?
My lord, it's CPR 3117, 3118, 1739 to 1740.
Thank you.
And can I then take the court back to a quote, which I think the court was taken to by my learned friend, from Lord Diplock, and it was referenced in a case called Taylor and Lawrence, and it's at page 2557. And you were taken to the end part, which was the needs must part. This is page 2557. But I'm actually going to the early part of the quote from Lord Diplock at C, in which Lord Diplock held the High Court's powers to dismiss a pending action for want of prosecution is but an instance of a general power to control its own procedure, such as to prevent its being used to achieve injustice. Such a power is inherent in its constitutional function as a court of justice. And that is my further response to the observation of my Lord, Lord Briggs, so far as concerns the application of inherent jurisdiction after the trial. There are limits to the exercise of inherent jurisdiction. See Lord Dyson in Aurari at para 22. But the court should be astute to ensure that its procedure, to control its procedure to prevent an injustice. And if one doesn't take a case in extremis of 40 years ago, but takes a case that settled days before, in this case the form arrived, yes, in those circumstances, should it have been necessary, which it was not on the facts of this case, because the court the trial documents remained at all times with the court, but should it be necessary, then the court can do that to avoid an injustice, not least when it requires absolutely the minimal of steps to be taken, simply to put the bundles which have, had they just been removed, to put them back in the court. Invite the court to step away from requiring to determine the issue of whether that inherent jurisdiction exists in perpetuity. My lady, can I now just address briefly practical considerations? And first just make this point, that in Guardian News itself, at paragraph 11, concerns of a practical nature troubled the district judge. That's page 1337. C, E to H. Yet Lord Justice Toulson proceeded apace. Lady, can I move on to the fifth issue, which is the trigger for the default position? And I now will have to move with some speed. This is the cross appeal. It's our notice of cross appeal is set out at pages 45 to 46 on this issue, paras 12 to 17, and our case at paras 77 and following, which is pages 185 and following. Now, this I cannot deal with shortly. This is our case that the Court of Appeal at paragraph 112.2.2, which is at page 260, and I'd ask the Court just to go to that, please. Unnecessarily and inappropriately limited the type of documents over which the court has jurisdiction. So that was the part, and see the observation of my Lady Hale yesterday, that this was a requirement that they read out in open court and that the judge is invited to read him in open court, or which the judge is specifically invited to read outside of court, or which it's clear or stated the judge has read. And I have made all of my submissions in relation to this issue already. I sought to set out our case as to why it is that the court should be providing access to documents, and that's documents which have been referred to in open court, including documents even as far as that the judge has not read. Lady, that approach is absolutely on all fours with the approach adopted in the Commonwealth. See our case at paragraphs 99 to 110, pages 190 to 193. And for want of time, I will not go through those cases in turn, but I will take you, if I may, to simply one quote at page 4535. We're now in Television News New Zealand Limited against Rogers in the Supreme Court of New Zealand, C4509. Just want to take you to page 4535, around number 15. The court must be careful in cases such as the present, lest by denying access to their records they give the impression they are seeking to prevent public scrutiny of their processes and what has happened in a particular case. Any public perception that the courts are adopting a defensive attitude by limiting or preventing access to court records would tend to undermine confidence in the judicial system. And so it continues. Lady, can I then go on to the application of the open justice principle to this case, which is appeal ground 2? Here, Cape promotes 2 cases, one in its grounds and one in its written case. In its grounds at pages 23 to 24, it says that the court was wrong to conclude that the open justice principle applies when a trial has taken place, but the court has not been required to give judgment and has not done so. That submission makes no appearance in the written case, nor did it make an appearance orally. So I will deal with it in very short order. Our response is that the effect of Cape's submission was that the open justice principle was not engaged unless and until there was a judgment. That is an unsustainable proposition, hence, no doubt, it no longer being pursued. The trial is an open court, and plainly the principle of open justice applies at that time. Hence, the media's opportunity to report the trial contemporaneously, and any non-party's ability to access documents at that time, the very arguments that, or witness statements I should say, per Cape, the very argument that forms part of their case. Mr. Justice Bean addresses the issue of a settled claim. I'll just give you the reference, if I may, in the judgment that I've already highlighted called NAB in Serco, paragraphs 38 to 39 of his judgment, pages 1491 to 1492. Cape's submission in its written case is rather different. It relates to the timing of the application. It's argued that the trial judge is functus officio when the case settles, and so the court cannot exercise its case management powers to allow a non-party access to trial documents. Forum's response, in short order, is that this submission cannot survive in recognition that a non-party is liable to be interested in a case as much after promulgation of a judgment or settlement as before. I make 4 submissions in support of that. First, the public may develop an interest in a case after as well as before it's resolved. Plainly, contemporaneous reporting by the press is of great importance. And see here, and I'll just give you the reference if I may, in Cuja, from Lord Sumption at paragraph 16, pages 1557 to 1558. He says it's been recognised for many years that press reporting of legal proceedings is an extension of the concept of open justice and is inseparable from it. In reporting what's been said and done at public trial, the media serve as the eyes and ears of a wider public, which will be absolutely entitled to attend, but for purely practical reasons cannot do so. And that may have been part of the quote I had in my mind in relation to you cannot expect, even the press, we'll see one on the press, and a friend I expect will take you to it.
And if you had an investigative journalist, he would only want to investigate the records at a later point in time when he's putting a story together about a collection of cases.
Lady, absolutely. It may be a number of trials that lead to identification of a live issue. To be honest, the point is so straightforward that I perhaps shouldn't enlarge too much. In Cuja itself, at paragraph 19, which is page 1559, Lord Sumption continued that the media may have a legitimate interest in publishing reports of material derived from court proceedings, but not contemporaneously. Yes, we say, of course that's the position. Secondly, logically, there is no good reason to think that scrutiny of the judicial process should be time limited. Justice Lewis, in a case called ABC and Y, although we don't agree with very much of what's said in that paragraph, does use a graphic description at paragraph 22, which I'll give you the reference, it's page 2848, but we don't accept what he says before that. But he says that's not to say that an iron curtain descends once litigation is concluded, even if it is concluded by settlement. And that, of course, is the effect of the submission made by Kate. And see Lord Mance in Kennedy. Can I take you to this, please? This is page 1413. And it's paragraph 26. Practical, the court have that, it's 1413, paragraph 26. The practical impact of the phrases is, of course, somewhat different in each case. In the case of a court, the rules of court, and in the case of the superior courts, the exercise of the court's inherent jurisdiction, means that the court can at any time, during or after the conclusion of proceedings, hear and adjudicate on applications for the release or disclosure of documents held in court or by court staff. This is a case in which CAPE accepts a CPR 5.4C2 is engaged after settlement of a case. Right on 5.4C2's jurisdictional ambit, then there is nothing here in ground 2, and if we're not, it's under the inherent jurisdiction, which of course, furthering the open justice principle, should mirror the extent of 5.4C2. And no countervailing public interest has been raised by CAPE as to why it is that there should be a time bar or an iron curtain, so described. Thirdly, my lady, the court is not functus officio, but endures after individual litigation has resolved. I add as a separate point that the PL claim had settled, the CDL claim had not settled when we made our application for the court documents, and the PL defendant had a Part 20 claim afoot in the CDL litigation. Claims were linked and, of course, heard together. But in any event, whether or not Mr. Justice Picken was functus officio, the court was not. See the R and Cripps case that Kate referred to in their written case, and can I take you to this at page 2211? Which in the judgment of Sir John Donaldson, MR, between F and G, it said some passing confusion occurred during the course of the arguments as a result of the use of the phrase functus officio in two rather different contexts. Most courts continue in existence over a period of time and deal with many different and separate proceedings. Questions arise as to whether and to what extent the court has finally disposed of each proceeding or issue arising in such a proceeding. When it has, the judge who presides is said to have become functus officio, quoad that issue or those proceedings. And the forum's application was not made to Mr. Justice Picken. It was made to the court, and it was heard by Master MacLeod. This was precisely the approach adopted by Mr. Justice Park when disposing of a comparable argument in the Chan Yu Seat case, and I'll just give you the reference if I may. It's paragraph 28, and it's that's the bundles, but it's 1188. That was in respect of CPR 5.4C2, and it was contended that that was time barred. And exactly as Lord Mance approached matters in Kennedy at paragraph 26, the inherent jurisdiction of the court is also not time barred. It's inherent jurisdiction of the court, not of a particular judge. None of the cases suggest there is or should be such a time limit, and there are many of them. I'll just give you our paragraph in our case, para 117, and we made an error, we said 118 later, it's 117, and it's page 195, and there are a number, a considerable body of first instance decisions. And the BAT case, which I'll go to in a moment, but just give you the reference at para 44.8 at page 3217, but I'm going to go to this case, in which Lord Justice Green said it is not relevant that the litigation is at an end. Finally, can I turn to the seventh issue, which is the legitimate interest of the forum, and this is in response to the question from Lady Arden. This is Appeal Ground 3. And Cape's case, in its grounds of appeal, pages 24 to 25, is that the Court of Appeal was wrong to conclude that the forum has a relevant legitimate interest. The forum's response is to make two submissions. The first is, a non-party does not need to establish an interest in scrutinising the trial. Second is that anyway, the forum had an interest in the substance of this trial. On the first point, the rationale, as I sought to submit yesterday, is one of transparency. The documents enter the public domain, and as such there is a prima facie right vested in all members of the public to access them. Protection of that principle would be frustrated if it was necessary for each and every person to establish proof of an intention to scrutinise the judicial process. And furthermore, it would be inappropriate for the court to seek to control access to the documents in this way. Logically, there does not need to be a marrying of the rationale of a principle of great public importance with the private motive or interest of a member of the public. In the BAT case, this was all drawn together. It's very recent, I think it was the 21st of December of last year, so it's post Cape and Dring in the Court of Appeal. But the matters were dealt with in attractive language by Lord Justice Green. If I can go to 3213, what I'll probably have to do, for want of time, is to highlight a number of paragraphs, but I would invite the court now to turn it up, but also to have regard to this judgment as well. Can I ask the court to note, starting at 3213, paras 27, 28, 30, which talks about transparency and openness, 33, when he references an NGO. There are some considerable comparisons between the position in the BNT case with an NGO interest in limiting the harm caused by smoking to children, in the case here. 34, with a quote referencing the position of pressure groups acting as guardians of the public conscience. 36, emphasising that increasingly judges sitting in open court rely upon documents they've read before the hearing starts, and so on. 39, I have an inherent jurisdiction to order disclosure of the documents in question. This was all after the hearing. 41, it's not evident from the this is page 3217. It's not evident from the jurisprudence which explains why open justice is important that in a case where evidence has been freely referred to at a substantive hearing, the reason why a person seeks access should be determinative. Since with only very limited exceptions, any member of the public is entitled to walk unhindered and without having to give an explanation into a court to witness proceedings, it is hard to see why such a person making a request for documents which assists an understanding of the proceedings should have to justify the request. Openness is an important constitutional virtue in its own right, and the courts are unlikely in cases such as the present to wish to become the arbiters of the subjective reasons why individuals seek access. And then see his summary, we'll see para 43, and then his summary at para 44, which includes the end part that I read out. It's not relevant, the litigation's at an end. And purely for interest, and in line with the New Zealand quote that I provided earlier, the sense that the sky may fall in if a court is transparent is not shared in the Commonwealth. See paragraph 46, in which in the US, in relation to the tobacco industry litigation, the courts ordered a disclosure into the public domain of vast amounts of internal tobacco industry documents exceeding 50 million documents. The court should not be defensive, should not be afraid of the implications that we invite the court to adopt.
A small point.
Yes,
under
ma'am.
5.4c, the court can restrict the disclosure from the court records of the statement of claim. But that appears to be only the statement of claim. Is there any reason why that should be so? Statement of case.
My ladies, the court can certainly restrict disclosure of the other documents on the court records because 5.4c2 is an application for the exercise of the court's discretion.
Indeed, under that provision, but not
Yes.
of the other documents.
I think that's, as given in response to an observation from Lord Briggs, that was a product of the press, and we now have all the CPRC documentation somewhere within there. The press promoted their case that they would like a sort of prima facie right to the statements of case, and so it was limited to the statements of case. So that's an incident of the genesis of that particular rule, which we have documents to show. My lady, on the second point, it is the case anyway that the forum is acutely interested in the substance of the trial. And for these purposes, can I go back to the Statement of Facts and Issues, pages 97 to 98?
You've got 2 minutes.
Yes, my lady, perfect. Paragraphs 4.2 to 4.5. This is the litigation. This is not us. This is the litigation. This is what was an issue in the litigation. 4.2. It was alleged by the PL claimants that CAPE had been negligent in respect to the production of its boards, and see the end of 4.2. There were allegations about what CAPE knew of the risks of asbestos and when, and that it failed to take steps to make those risks clear when it should have done. See 4.3. It was alleged CAPE had superior and particular technical knowledge. This included the knowledge of the Asbestos Research Council on the basis that these organisations were simple mouthpieces of CAPE. And I'm skipping to 4.4. It was alleged that CAPE failed to disseminate its superior knowledge, but instead obscured, understated, and unfairly qualified, thus providing false and misleading reassurance. Slightly lower down, it's also alleged that the ARC lobbied the government when it came to formulate the Asbestos Regulations 1969. Then, if my lady will turn to paragraphs 25 to 28, which start at 104, the court will see that those are the very issues that interest the forum. There's a complete mirroring of issues. I won't read it out, but you can see that includes reference to the PowerPoint slides that led to understanding that the case had settled, but that it had revealed and put in the public domain important documents which the master found we would not otherwise be able to obtain in ordinary party-and-party litigation. And so we would be in what I think I described right at the outset to Master MacLeod and went into her judgment as an intolerable position. that one High Court judge would have had access to documents put into the public domain, highly pertinent to other litigation, which we would not be able to access. So, my lady, very much on the facts of this case anyway. Forum was concerned with the substance of litigation. My lady, I've sought to emphasise earlier this morning that there is no challenge to the exercise of discretion in this case. That ship has sailed. And that is why we ask the court to restore the order of Master MacLeod, not via the convoluted mechanism of going back to Mr. Justice Picken for him to make any determinations, because there is clear, crystal clear evidence that the trial documents so defined in paragraph 1 of our case have all been relied on and referred to in open court. And the Master exercised her discretion wholly in favour of the forum in relation to that issue, on which there is no appeal. Thank you for letting me go 2 minutes on. Unless I can assist further, those are the forum submissions.
Thank you very much indeed, Mr. Weir. Mr. Butters?
My
Yes,
lady,
Mr. Bunting.
the intervener is an association of in-house media lawyers from a variety of different media organisations. The corporate members of the intervener are set out in the core volume at MS 87 to 88. As the court will see, it includes... Sorry. Sorry. As the court will see, the corporate members are set out at 87 and 88.
Yes.
And they include media organisations from press, from broadcasting, and from new media such as the internet. They have considerable experience in litigating access to court documents. They have considerable experience in responsibly reporting the courts. And it's their case that at a time when the veracity of media reports is under sustained challenge, it is absolutely fundamental for them to be able to access accurate material. And very frequently that accurate material will come from court records or court documents. The media's ability to report is threatened when its ability to obtain information is narrowed. I'm going to set out my submissions in the following way. I'm going to draw attention to 4 particular problems that the appellant's approach would pose before proposing a solution. And the solution is the carefully calibrated proportionality exercise set out by Lord Justice Tolson, as he then was in the Guardian News and Media case. And that approach, which was founded on the inherent jurisdiction of the court, reflects, in my respectful submission, a uniform approach to open justice throughout the common law world, whether there are rules in place or whether there are not. And I'll touch upon 2 authorities at the end of my submissions to make that good. Turning to the problems, can I first of all emphasise the importance of the media? The papers before this court are replete with justifications for the open court principle. And frequently that justification turns on ensuring public accountability of the justice system. But there can be no public accountability unless the public have knowledge of what is happening in the court system. And that knowledge frequently comes from the media. That is why, as Lord Reid held in ANBBC, page 1505 at 26, the open justice principle is inextricably linked to the media's freedom of expression rights. The public get participation in the system through the media reports. And the court has seen Lord Sumption's comments to that effect in Kudra already, but there's a particularly helpful summary in the McCartan-Turkington-Breen case when Lord Bingham addressed how the public obtain information through the media. The reference is at MS 6049 at G. And Lord Bingham said, in a modern developed society, it's only a small minority of citizens who can participate directly in the discussions and decisions which shape the public life of that society. The majority cannot participate in the public life of their society in these ways if they are not alerted to and informed about matters which call or may call for consideration and action. It's very largely through the media, including, of course, the press, that they will be so alerted and informed. The proper functioning of a modern participatory democracy requires that the media be free, active and inquiring. And that logic applies equally, of course, to the court system. And there are numerous authorities within the bundles which suggest that the media is the eyes and ears of the public when it comes to what happens in our courts. Given that accurate information is a key tool of the journalistic trade, it will often be necessary for media organisations to gain access to information in order to perform that role. Obstacles that hinder access to information for the media may result in a media not being able to play its watchdog role in that effective way. And that not only undermines the work of the media, but it undermines the ability of the public to know about, understand and scrutinise the court system. The appellant's approach would lead to particular problems, and it would lead to, in my respectful submission, a narrowing of public awareness of justice. And I'm going to draw attention to 4 particular problems. My Lady Arden has already anticipated at least one of those. The first problem is, if my learned friend Mr. Fordham is correct, the media would effectively be required to be present during every civil hearing in which they have an interest. And that is unrealistic. It's unrealistic for the reasons given by Mr. Justice Park in Chan Yu Sik, see page 1193, paragraph 45. There are a great many courts sitting every day in the Royal Courts of Justice alone, and there are vastly more around the country. A newspaper cannot realistically be expected to have reporters present at all times, in all cases in which it's taking an interest. As my Lady Arden recognised, journalists will potentially only become aware for the first time of the significance of a case when they're investigating a particular issue after the case has been determined. And that recognition is consistent with the comments of the New Zealand Law Commission when it was considering access to justice in the very final tab in the authorities bundle. The reference here is 6966-7. And it was said to the New Zealand Law Commission by the Lord Chief Justice of New Zealand that the open justice principle was satisfied by open court hearings and judgments becoming available. And the New Zealand Law Commission rejected that. They said, in our view, the transparency of the judicial process extends to public access to the records of court cases. To be effective, open justice requires presumptively open access to court records, at least from the start of the hearing. Access to records at the time of the hearing should ensure accuracy of reporting by the media. At a later period, the possibility of miscarriage of justice may come to light years after a case has been decided, and records may need to be pursued at that stage. At a later stage too, a person or organisation may need to research historic cases to investigate issues of public interest and concern. The second problem with my learned friend Mr. Fordham's approach is that it elevates the trial judge to someone who will effectively have to take preemptive editorial decisions about what may or may not be of legitimate public interest when investigating a case. And that, in my respectful submission, is a distraction from the trial judge's essential task of efficiently doing justice between the parties. And that was recognised by Lord Scarman in his minority judgment in the Harman case, when he said that trials will often give rise to public interest issues outside of the issues between the parties. See page 1138 at F. But it's put beyond doubt by 2 further authorities which are in the bundle. The first of those authorities is Independent News and Media, a case which is at page 6191. And it was an unusual case in which journalists were seeking access to court of protection proceedings about the financial affairs of a blind and disabled man who was a musical prodigy. Lord Judge, Chief Justice, with whom Lord Newberger and Sir Mark Potter agreed, held that the litigation is about A's interest and the involvement of his devoted family, and the judge must concentrate on them and will produce a judgment which reflects his decision about the matters in issue before him. He is not qualified to determine what is or may be of interest to the public. That is the function of the media, not the judiciary. In any event, it would be an inappropriate exercise of the judge's responsibility if he were to seek to tailor the contents of his judgment to what he believed to be the needs or concerns of the media. And that, of course, reflects Lord Rogers' familiar warning in the anonymity case in Re Guardian News and Media. Judges are not newspaper editors. Writing stories which capture the attention of readers is a matter of reporting technique. Judges recognise that editors know best how to present material in a way that will interest the readers of their particular publication and help them to absorb that information. The third problem is, how can the media accurately inform the public if, after a trial is finished, they cannot access witness evidence or the written arguments in a case, which would be the logical result of my learned friend's reading of CPR 5.4c. Those documents are often the key documents sought by the media, but the media would be prevented from seeking them if the appellant is correct. The fourth problem is what happens outside of the narrow confines of this case, which arises in the civil proceedings in England and Wales. Much turns on the interpretation of the words records of the court in the CPR. But of course, that phrase isn't present in the equivalent provisions of the criminal procedure rules. See page 5231, rule 5.8. Nor is it present in the rules of the Court of Judicature in Northern Ireland. See the AB case, MS 6273. Nor, as far as I understand it, is that phrase present in any procedural rule in Scotland, whereas I understand, pursuant to my Lady Hale's question yesterday, there are in fact no formal rules regarding third-party access to court documents. I've put before the court this morning a case called Haney, in which the High Court of Justiciary in Scotland granted the BBC access to some exhibits in criminal proceedings, but not all. It's a judgment which turned effectively on the res balancing exercise of Articles 8 and 10, as opposed to the inherent jurisdiction of the court. And in coming to his conclusion, Lord Woolman distinguished the judgment of the Divisional Court in Guardian News and Media. And the court will notice right at the end of that report that the law reporter noted that in any event the Court of Appeal overturned the Divisional Court's approach in Guardian News and Media, with the result that Lord Woolman's approach is effectively the same as that south of the border. My learned friend Mr. Fordham has produced some further researches which suggest that a member of the public petitioned the Scottish Parliament to have de facto public access to all court documents free of charge, and the Scottish Parliament found that that was an impractical suggestion. In so doing, the Scottish Parliament had regard to the views of the Scottish law courts, which said that it is open to people, including journalists, to apply for court material using the powers of the court. And so what is the solution to those four problems? And the solution is very clearly given by Lord Justice Tolson in Guardian News and Media. That's a solution which permits requests for access to be assessed on the basis of a fact-sensitive proportionality exercise. And within that exercise, the problems posed by a request for an inordinate amount of material, or by a request made long after the conclusion of a case, or a request for a particularly sensitive material, or indeed a request for an improper purpose, are all things which can be taken into account when deciding whether or not to grant access. Secondly, it gives due recognition to the rights of the media by creating, as Lord Justice Tolson recognises, a particularly strong default position of access. Thirdly, it avoids courts having to exercise editorial judgments about the adequacy of material available to the media. See paragraph 82 of Lord Justice Tolson's judgment. And fourthly, it fills in the gaps in the CPR which do not formally cover the types of requests that sometimes arise. It can therefore permit written submissions and evidence to be sought after proceedings are complete, consistently with the Iron Curtain comments of Mr. Justice Lewison. It can also permit, as Mr. Justice Leggett found in the Blue and Leggett case of paragraph 10, the court to order a party to provide material to a journalist. And incidentally, that is a power which was also applied in the Re Watchstone case by the Business and Property Court. See page 6285, paragraph 25, in which it was accepted as good law. But of course, as my Lord Briggs recognised, that will only be something which a court may do in an exceptional case. It may consider applying the proportionality exercise, that it is unnecessary to do that. And frequently, in terms of media requests, the media are only requesting a narrow class of documents, as opposed to the whole morass of trial material that may arise in other cases. And for those reasons, it's no surprise that the inherent jurisdiction identified by Lord Justice Tolson has been approved and applied at every level of the justice system in this country, as I've set out in the written case C205 to 210. It's been applied in the upper tribunal, in the administrative court, in the Queen's Bench Division, the Business and Properties Court, the Competition Appeals Tribunal, and the Courts Martials. Put simply, Lord Justice Tolson's inherent jurisdiction approach is woven into the fabric of the common law now, and it is a radical step to try and unpick that. And it's correct, finally, if I can, that proportionality exercise, because it also reflects a uniform approach to court documents throughout the common law world. And I've set the various positions out in the intervener's case at page 212 to 218. But can I just draw attention to two cases in particular, if I have the time? The first is a judgment from 1982 in Canada, the Supreme Court of Canada in McIntyre. And that appears at page 4319 of the bundle. The judge was considering a request for a search warrant granted pre-trial. And Justice Dixon surveyed the law in America. He surveyed Bentham. He considered Scott and Scott and other English authorities. And he concluded at MS 4323 that at every stage of the trial process, the rule should be one of public accessibility and concomitant judicial accountability. That was an exercise of inherent jurisdiction, as he set out, see 4326. Undoubtedly, every court has a supervisory and protecting power over its own records. The presumption is in favour of public access. And just if I can, the second case, which may require a little further attention.
Well, you've 3 minutes.
It's the case of the Hong Kong case of Secretary of State for Justice in FTCW. And that appears in the bundle at 6785. And it's important because Mr. Justice Lamb, the Vice President of the Court of Appeal of the High Court, cited and approved Guardian News and Media, and he applied an inherent jurisdiction notwithstanding the fact that there were procedural rules which sought to regulate the way in which access to court material can be granted, see paragraph 15. The court specifically rejected the argument which is advanced in this case, and which was incidentally addressed by Lord Justice Tolson in Guardian News and Media, that where there are rules of procedure, the inherent jurisdiction falls away. And the paragraph 15, the court says, 16, sorry, it's clear beyond peradventure that the court has inherent jurisdiction to control access. It fills the gaps. The rules of court are not a comprehensive code and did not have the effect of abrogating any common law power of the courts. Put simply, throughout the common law world, whether there are rules of procedure or not, the same balancing exercise and proportionality exercises arises. My lady, after this case, to my embarrassment, people will be able to watch these proceedings on the internet. If necessary, those sitting behind me will be able to tweet about these proceedings on the internet. And as my lady, you recognised in your lecture to the Greys Inn last year, in the Sir Nicholas Wall lecture, sitting in the Supreme Court, one is only too well aware that our much vaunted transparency is not much use unless those with a real interest in the case can see the parties' written submissions and even some of the supporting documents. Those 3 steps which this court is contemplating or has taken would be exercises of this court's inherent jurisdiction. And I respectfully invite this court to find that other courts below this apex court have that same power, that it is not so narrowly construed as set out by the appellant, and to approve once again, if that is needed, the approach of Lord Justice Tolson and Guardian News and Media. Unless I can assist the court any further, those are the submissions of the intervener.
Thank you very much indeed, Mr. Bunting. Thank you.
So far as the intervention is concerned, the court will have been struck by two things in particular. The first is that, as I showed you on page 219, their conclusion in their written case in this intervention is all about evidence relevant to a court's decision. And that's what they say open justice needs at paragraph 41 on 217, and I showed you that. But secondly, as you also saw, when the Civil Procedure Rules Committee specifically consulted on Guardian at page 3927, paragraph 3 is Guardian, paragraph 2 is now what documents are needed, what classes of documents, claim form skeletons, judgments and witness statements, and then the committee, page 3928, paragraph 4, has taken the view that the limited change being proposed, that skeletons in the Court of Appeal, is in line with those principles. Then all the rules set out, the consultation response from the very same intervener, because we saw it was at 3950, and they said at 3950, 3 paragraphs from the bottom of that page, witness statements must be available and open to inspection. There may be a need for access after the proceedings. That was it. That was their position on what was actually needed, and you've just heard it.
Sorry, who were the News Media Association? Is that the same as the media lawyers?
It's a corporate member of the Media Lawyers Association.
I'm sorry, I should have made that clear.
And it was a
Yes,
consultation about
I
a very specific-
realised yesterday they weren't
Yes.
identical.
So the corporate member who is being consulted and who is speaking up.
Thank you.
And as you've just heard orally, what they say they really need, skeleton arguments and witness statements. Now, my Lord Sales asked about knowledge and whether we'd got any evidence about what the forum was doing. And you were told, well, the solicitor was alerted after the case had settled by attending a lecture. In fact, there is a witness statement at page 435 in the main bundle in which it is specifically explained that that solicitor with her 30 years of experience in relation to this area was already aware of this litigation, and indeed she describes it as being litigation that was very well known. So that's the evidence so far as that is concerned. And one of the ironies is that they are asking to be put in a much better position than they would have been. They want copies of everything rather than having a trial judge saying, well, you can inspect, you can't take it away, but you can look at it and you can read it. And you can look at the witness statements and let's see what's being adduced and whether anything else contemporaneously is really needed. My Lord Sales also asked my learned friend for the forum about the position after the case is over. And he says, oh, well, it's not this case, you don't need to worry about it. It is this case. It cannot be said that a judge's hard copy trial bundles that have been used in the pre-reading and in the preparations and are now finished with and are in the out tray waiting to be collected, and we're entitled to have collected them, are the basis for access to documents. And anyway, as you know, the Court of Appeal in its order made a mandatory order, and the missing paragraph when you went back through our submissions is 945 paragraph 7, which I showed you, which was us saying to the Court of Appeal, that's what you've done. This is the logic of your order, so embody it in an order. This is all about a case after the proceedings have been finally determined, and it must be all about a mandatory order in relation to a third party we submit. It would be very odd to try and parade all this constitutionality and principle and then I'll draw the line and say, don't worry about that. Mr. Justice Leggett at page 1541 was the judge dealing with the proceedings in relation to which there was about to be a trial. And the fact that they won't even answer the question of where does this jurisdiction end? Oh, don't worry about that. But we say there isn't one. They say there is one. We do need to know what they say this jurisdiction is and how it endures. They said they would deal with the implications practically. You had less than a minute on that, and the only point that was made was, well, the district judge was bothered in Guardian and Lord Justice Toulson was not. But the implications are very important. prima facie right of public access to trial documents, or at least once a trial has started, after the proceedings are finally determined, under a freestanding jurisdiction of the court, alongside a rule that specifically deals with it, and even from the judge's marked up trial bundles, or alternatively, a mandatory order. What then new arrangements does this new jurisdiction that hasn't been needed for all of these decades? What are they to be? The trial bundle is an extra copy, a clean one to be retained in the registry with other stored documents, with all the logistics that are involved in that. When can they be accessed? Does the trial have to involve a record being taken of what is actually relied on? The trial bundles, as my Lady Arden pointed out, and this is entirely consistent with the witness statement that you've seen, that's how it was prepared, the intention to be available. So you then see, as the trial unfolds, what is being read or invited to be read, what is being relied on. Is there to be a record then of all of that to avoid having to do a reconstruction? Is there to be an inspection bundle? Is it to be kept for more than 7 years to discharge the open justice principle because the press may want to write about a case a long time after the event? Put yourselves in the litigant's position. The case has settled, it is over. You filed a trial bundle, it was delivered to the trial judge, for the trial judge. It went through the court office, it was returnable to the parties, like an exhibit is returnable under the rules to the parties after the trial. The position is clear. The trial judge had the responsibility at the trial for open justice. You'd put together the documents that were intended to be available, and then the trial proceeded. The witness evidence and experts were available to look at, inspection during the trial under the rules, not copies to put up on the internet. And the skeleton, had it been sought, would also have been dealt with under clear authority from the Court of Appeal. Now, in a trial that proceeds to a judgment, all of the documents are then contextualised. The judge explains, this is what it was, this was the significance in a fair-minded evaluation and explanation. And what the litigant now faces on an ad hoc, after the event basis, with no support in relation to arrangement or rules, is either, well, let them have it all, so they can upload it to the internet, or have the proportionality exercise of a re-evaluation. And there is a reason why this is unprecedented. There is a reason why neither of them have been able to show you any case in any of these bundles where, after a trial and a settlement, a non-party has a right to the copies of the trial bundle. There are also good reasons why there are no applicable rules, still less in relation to judges' marked up bundles. Around the world, wherever you find frameworks of rules, the one thing you will never be able to get are the notes that are made by the judge as the records from the court, something that the committee has specifically addressed. It's unprecedented, and it's unprecedented for good reasons of principle and policy as well as practice.
Well, I recall, Mr. Fordham, when I used to sit in county courts, it is admittedly a very long time ago, I was told that my notebook was not my notebook, it was the court's, and it formed part of the matters which the court kept. I don't know whether things have changed, because this was before the CPR, so maybe things have changed. And maybe the judge's notebook in a county court is not, in effect, the record, which was what it was treated as in the olden days. Has it changed?
I don't, of course, notes of evidence and the judgment and the ruling of the court, but the notes that the judge makes on the documents, marking them up, the draft judgment that the judge may have created. My point is that there's no public right of access to those documents. And when someone like the New Zealand Law Commission looks very carefully at these matters, they exclude that. The Rules Committee also looked at that point specifically, it's minuted, and explained why they regarded that as inappropriate. The implications for the parties as to what we send the court office or goes direct to the judge as to how we deal with bundles, or our preparation, or our lists, or our reading lists, or our skeleton arguments, are all informed by knowing what the rules are and having some certainty and having some stability. And what are our duties? Are we allowed to collect bundles? Are we allowed to destroy materials? Are we supposed to retain documents? If so, what? And for how long? Records of the court. It comes to this. The forum says presumptive public access to all documents filed, delivered to the court office while they are still held by the court. That immediately overlooks the idea of the court file as a collection that is held as an archive. We saw that in the New Zealand Supreme Court case of Moffat. And it's a collection as a matter of practice, not the tail wagging the dog, but the practice of the court under the oversight statutorily required of the Lord Chancellor, because it's his Section 8 responsibility under the Public Records Act. And that's what you saw in the materials, both that section, but also at the top of page 3237, the 1833 Act, talking about the Lord Chancellor's responsibility. Those will immediately be massively expanded. My learned friend is right. It's any document filed that is still within the court building where filed is. It goes through the court office. It also overlooks the repeated references. When you went through that history lesson, Caddy, case about a writ, the Chancery Orders, the 1965 White Book, it's in there every single time that we're talking about materials securely kept for access, or the phrase is faithfully and safely kept. Caddy at page 1979, the Chancery Orders in the middle of page 3490, and at the top of page 3505, and in the White Book of 1965 at page 3519. It's always access to a collection of documents that are being kept as a collection in order to be accessed. And the words didn't change, that's right, from the rules of the Supreme Court. The words didn't change the position, that's right, from the rules of the Supreme Court to the CPR, but they did reinforce it. GIO had already held, at page 1159 in your bundles, that the access is to the documents accessible from the central office, those being the words of the rule, under Order 63, Rule 4, as a record. And Lord Justice Potter pointing out trial documents are not held as a record. So in fact, the wording is reinforcing when it's from the records of the court, or as it said for the Attorney General, from the court file. And if you're going to look at Lord Justice Potter on the history at page 1161, would you please read the whole sentence of what he's saying? Documents, that is to say evidence in trial bundles, have never, as a matter of history, been the basis of public access on the basis that they've been read or referred to. And that's right on both counts, and not for a moment disproved by the history voyage that we went through. The court-ordered lodging of a document in court is about depositing documents. You saw that in Order 63, Rule 5. That was page 3714. And if you're interested in Hinchliffe and Mr. Justice Bean, this was the point about, well, if you're inspecting a witness statement or an affidavit, you must be able to look at exhibits. That is clearly wrong, so far as the inspection of witness statements under what the rules have always involved, with that certification exercise being available for 7 days, now under the rules, 3213. This is addressed in Nestek, the case that we went through towards the end of my submissions. Why is it wrong? Because what you are allowing access to is that which stands as the evidence in chief. And if I exhibit a letter that I've written or a letter that somebody else has written to me, that is not standing as the evidence in chief. My learned friend also has a false paradox. He says it's a paradox if you can get to see interlocutory matters. But you know from 1967 onwards, page 3530, The White Book commentary was explicit about that these are interlocutory in character. On the same page that cited Associated Newspapers, 3530, which was a case about access to an order. So interlocutory is explicit. There's no paradox here. You get orders and judgments, you get claims and applications and those things that support applications. Before a case is heard, you can find out, just as with a case register, what's in the courts, and you can also look at what's being asked for. And after the case is over, you can see what comes out the other end, the order and the judgment. But there's no paradox in having court records that include those sorts of materials, but don't have the 17 lever arch files from a single Queen's Bench trial. My learned friend also misreads Section 32 of the Freedom of Information Act. That was at 3421. He says, the etc. in court records, etc., is Section 32.2 on that page about inquiry and arbitration. But you only have to examine 32.1b to see that that is wrong. And so 32.1 is already more expansive than court records, as is the description at 32.1a. And therefore, there's nothing to be gained from that. Indeed, that would fall foul of Lord Chawson's looking at the matter from the wrong end in Kennedy at paragraph 106, page 1440. That was all about don't use the Freedom of Information Act to seek to give yourself the answer so far as the powers of the court are concerned. The implications on this record of the court argument come to either this, a backdoor rule like in the insolvency context, that was page 3476. 3476, the rule that says if something is filed, it must be retained on the court file. That rule does not exist under the arrangements for the High Court. And or it would involve a tracking and preservation exercise. Something's gone through the court office. We now need to track what it is, where it's gone, who's got it, are they marking it? Why? Because there's a right to ask for access from documents from it, and we need to deal with that. There are very significant implications indeed for the court and the parties. And as the Court of Appeal explained at paragraph 47, it would mean that access to documents under the rule, 5.4c, would depend on happenstance. What does the court still have in the building today? And you'll be besieged with applications at that very window, not more than 7, not less than 3 days before the hearing itself. That's when you've got it, and that's when people are going to start asking for it. But wait a minute, this bundle is either waiting to go to the judge or it's gone to the judge and is being used by the judge. Now the mirror, next topic, with 3122, that's page 1742. Learner friend says there's a mirror. Rule 3122 about release from the implied undertaking, page 1742, is then mirrored by public access to documents. In response to that, firstly, the trilogy of cases, Bearings, Smith, Klein, Beecham and Liliakos, are not saying that Rule 3122 triggers a public right of access. Bearings, to take that example, was saying that you regard as being in the public domain for the purposes of a provision in the banking legislation, something which has been referred to in open court. But it wasn't so that access is provided under the rules. It was so it would be disclosable if disclosure was otherwise appropriate. And Lord Wolfe agrees with Lord Bingham in the Smith-Klein case. You see all of this in the Court of Appeal's judgment at 74 and 77. And this is the one about don't allow too much of a gap. If we look back at the Court of Appeal, at paragraph 74, on this point, as is correctly identified, in his obiter comments, paragraph 74 in the Court of Appeal, Lord Bingham recognised there might be a need for greater safeguards, greater access with suitable safeguards, and not too wide a gap between public domain in theory, come back to that, and in practice. He was thereby recognising there was as yet no right of public access to documents which are referred to in open court. That's right. It actually goes further, because the sentence of Lord Bingham that is not quoted, but you will find at 1179, is Lord Bingham specifically saying at letter just above F, our ruling in this case permits SmithKline to use documents otherwise than the revocation petition that gave rise to disclosure, but does not in any way oblige SmithKline to make such documents available to the public if they do not wish to do so. So it's not about public access. It would be transformative of a rule that is about the autonomy of a party after an obligatory disclosure exercise to turn it into a presumptive right of public access to documents. That's not what that rule is driving at all. And I said I'd come back to theory, because it's not the case that documents that are releasable under that implied undertaking are available to the public. That's why it's theory. They are deemed to be for that autonomous purpose. And Mr. Justice Carnwath explains that point at page 2327 in a case called Plant and Plant. But it was obviously the point that Lord Bingham was also making. That's why you find technically in the public domain, or in theory in the public domain. Finally then, Guardian paragraph 85. I have accepted, and the authorities support this, that the default position in Guardian paragraph 85 is applicable to the discretion under the rule to allow access to the records of the court. That's what the Court of Appeal is saying at paragraph 127. That's the principle in the ABC case at page 2852. That's the approach. Put the rules on records of the court together with that default position, and it strikes the right balance. That's what the Rules Committee thought. Page 4133. And a good practical example in the bundles is at 6225, paragraph 95 of a case called Global. In applying the discretion as to access from the records of the court, I will apply Guardian 85. So it's not a question of whether that has a role to play. It's a question of whether it produces something that expands beyond the records of the court and is a freestanding jurisdiction with an indeterminate length, even after a case has been finally determined. There is no iron curtain. There is a rule. It's 5.4c2. There is a process. The rules tell you what process you have to issue. It is regulated. And there are stable arrangements with the secure holding of clean documents in the court file by reference to which that is applicable. Now that is a coherent use of the open justice principle and that default position. Its coherence is demonstrated by the New Zealand Supreme Court case that we saw, citing our Chan-U-Seek case that says no inherent jurisdiction, apply the rules. And in New Zealand, in the Supreme Court, that is what they say, and that is what we invite you to say. It's entirely reconcilable with Lord Toulson in Kennedy. He was at page 1442, paragraph 115. What he said was the fundamental reasons for the open justice principle of general application, but the practical operation varies. And here you have rules that deal with the practical operation. It would also be consistent with Lord Carnwath in Kennedy at page 1475, because it would not be a large step. Paragraph 240. But Kennedy wasn't dealing with the issue you're dealing with, the comments that were made weren't even dealing with an issue in that case. See paragraph 42, page 1418, Lord Mance, paragraph 234, 1474, Lord Carnwath And the context for Lord Mance's own comments at his paragraph 47, 1420, was he said, in Guardian, the Court of Appeal has upheld the criminal court giving access to documents in an extradition context to a journalist. Our rule has stable parameters and promotes certainty, and applying the open justice principle through it also promotes certainty, and it manages change. Because if the Rules Committee ought to be looking again and consulting again, well, then they will. Just as they did with claims registers when those were introduced, and just as Lord Justice Richard's subcommittee does. This use of the inherent jurisdiction does, we say, contravene the CPR, where there is an enduring and applicable rule after a case is over about what you can access. It is also, to paraphrase Lord Dyson at the top of page 1277, a major innovation requiring institutional steps to decide otherwise. And that is something fortified by all the points about the design of the CPR that Lord Dyson explained reinforced his conclusion in Al-Rawi, paragraph 61 at 1286. It is not, we say, necessarily implicit in the CPR that there is this freestanding power together with jurisdiction to make mandatory orders against non-parties, former parties or third parties. That was nigh credit at 2297 at letter D. If there is a residual jurisdiction based on Guardian 85, and I'm wrong about everything, then it must, we say, mean that there are these parameters. You would be looking for the documents or parts of documents that the judge read, or you can be clear that the judge read, or that the judge was asked to read. That's paragraph 108 of the Court of Appeal's judgment. It has to be a proportionality assessment because Guardian 85 at the end of that paragraph tells us that. And you can't have it both ways. And there must be clarity as to what the responsibilities are of courts and parties and third parties, and for how long. But most importantly, perhaps, end of the Court of Appeal's paragraph 110, the test must be whether the reasonable observer, remembering the position that the reasonable observer would have been in at the trial, needs a certain document in order to be able to understand the issues or the arguments that arose in the case. And is this case about scrutiny of the judicial process? No, the forum is not looking to understand something that it cannot understand about something that was said at an open hearing, and it makes no claim of that nature or of that basis. The Scottish material is all that what happened was there was a petition and an invitation to change, and it was regarded as being disproportionate. It wasn't taken any further. I'm not sure that material is going to assist you, but there is a clip of material if the court would like to receive it. Unless you've got any further questions, and I think just on time, I hope so. Those are the reply submissions
Within a minute.
On behalf of the appellant.
Thank you very much indeed, Mr. Fordham, and thank you to everybody, both those who've addressed us and those who've worked so hard, I'm sure, beavering away behind the scenes. Of course, everything that comes before this court is kept by the court and does go on the record. So I hope everybody bore that in mind when they, when they did their preparation. Anyway, we'll now go away and try and puzzle out what the answer is. Court will now adjourn.